Ladies and gentlemen, good morning to this very short flash webinar on obsolescence and property damage. Twisting case law of the Belgian Supreme Court is very short. I will remain within the 30 minutes to give you an update on this very specific, but I believe quite important element in certainly litigation when we're seeking to recover damages to property on the Belgian law. Perhaps practical information. My presentation can be downloaded on the right hand side on a handout of your screen. You will receive a certificate of the GoToWebinar after the webinar. If you attend, and keep attending. Questions can be asked. Obviously, we are on the webinar mode, but please feel free to use the chat function to give your question, feedback, comments, and I will revert to those after the webinar. You can also send me, obviously, your questions or queries via email. So, obsolescence, vétusté in Belgian law, and I will review some of the case law over the past 7 years of the Belgian Supreme Court in that respect. But let's first start with the principle or the principles of compensation on the Belgian law. These principles are general and are well established in Belgian law. And what are those principles? The main principle is a principle of integrality, so that the injured person or the person that has been caused damage to his assets by another person is entitled to a full compensation of the actual incurred damage. So the damages should cover the entire damage encountered or suffered by the claimant, so to speak. It's applicable to movable and immovable property. There is no difference in that respect in the approach of obsolescence to apply those principles. Also, there is no difference between contractual liability or liability in tort. You know, I put it on the screen, there is a difference between foreseeable damage, which is, let's say, the contractual damage scope, and liability tort. Also, unforeseeable damages can be claimed in the event of liability in tort. The principles you know. But there is also indeed a fourth principle that, let's say, I summarize as nothing less, nothing more, so that the injured person or the person indeed suffered damages cannot indeed receive more than the actual damage incurred. So a full compensation, so nothing less, but also nothing more than the damage incurred. So basically, the injured person cannot be in a better position after the incident than before, but he cannot be in a worse position. And it's basically on that, let's say, topic that there is case law, and that the discount, as we call it, for obsolescence will play in case law and in litigation. So that are the four main principles, or the two important principles: integrality principle and nothing less, nothing more principle under Belgian law. Why nothing more? That's based on the principle of the unlawful enrichment, as we call it. Indeed, that the injured person or the person indeed suffering the damages, legal person, so that his assets are indeed compromised, cannot gain anything about further to the contractual or the fault in tort by the other party. So that are the principles. And then indeed, obsolescence. What is it? Indeed, as we say, compensation should be based on the repair costs or the replacement cost of the damaged goods. Repair cost can be done with spare parts that are second-hand, of the same value, with the same wear and tear as the damaged goods, as the goods before the damage occurred. we see in reality that it's very difficult because we will use indeed new spare parts. Replacement cost. In principle, one could say, okay, a car was 100% a total loss, so we will replace it by the car with the exact same features and wear and tear, so all age as a damaged good. But in reality, that is mostly not feasible. A result of that is that there is indeed, in reality, in most cases, an added value for the party that suffered the damage. He will have a new car, he will have an asset that is repaired with new spare parts, so allowing a longer use after the repair, after indeed the compensation received than he was before the accident. So indeed, the debtor will have to be paying more. In reality, has a greater burden than the damages that he actually incurred to the victim, so to speak. And then is the question, there's a question we are talking about, the indemnity that have to be paid by the liable person. Will that have to be new value? So basically overriding the principle of nothing less, nothing more, or indeed, should his liability be limited by applying a discount for obsolescence of the assets? And that is indeed on the screen below, nothing less, nothing more. That is either new value, the victim will receive too much, actual value, in many cases it is too little to be placed in the previous circumstances, so the circumstances as if the accident or the incident did not happen. And that's a question that plays, and for years it was very clear that the discount and taking into account wear and tear should be done by the courts, and the Supreme Court of Belgium, indeed, in two cases that I highlight in my slides, February 2016, Dutch-speaking section, they confirmed that. So indeed, 2016, spillover fire, neighboring warehouse was completely destructed. There is a tort claim by the owner of the destructed warehouse against indeed the owner and the contractor of the neighbors, and they claim obviously new value because they have to rebuild the warehouse. Rebuilding of the warehouse with, let's say, spare parts or second-hand parts from the second-hand market is quite unfeasible in reality. But the wrongdoer was indeed only ordered to pay an indemnity based on the actual value, i.e. the replacement cost minus the value of the obsolescence, so that he received indeed the value of the warehouse that it had before the incident. So deduction, discount for wear and tear or application of obsolescence was confirmed 2016 very clearly. 2018, again, Dutch-speaking section, which is perhaps relevant or nuances a little bit the case law. 2018, the same reasoning, a truck accident, a truck hits a bridge, I think it was on the A12 Brussels-Antwerp, damage to the bridge, the Flemish region claims damages, and they say, indeed, it should be new value because on top of that, it's our goods of the public domain. So we need new value, pre-existing damage or obsolescence cannot be taken into account. And there again, that's a matter of principle, public domain or not, that does not play in the, let's say, in the principles of assessing the scope of indemnity to be paid. And in 2018, the Cour de Cassation, the Belgian Supreme Court, again we restated that there is an obligation to apply a discount for obsolescences also in this case. So that principle remains. It is not new value, it is indeed the actual value, the market value, the actual value of before the incident that should be compensated, irrespective of whether indeed the damaged party, the claimant, is able to build a new bridge with the indemnity, with the monies received from the wrongdoer. So indeed, you would say 2018 legal certainty. We have been applying this, let's say, since the beginning of my career. And as far as I know, there were no deviations from that, that we apply vetusted obsolescence. Quite difficult English words, as you have heard already. But there was indeed criticism in the by legal scholars, because they say indeed if the injured party is unable with the indemnity received to place himself in the same condition, that goes against the principle on the Belgian law of a full repair, of a full compensation, of basically deviates from the integrality principle. Other legal scholars obviously says, okay, but otherwise you have the enrichment without cause, an enrichment that has no legal basis, because the other party will be in a better position economically seen than before. And then the reason basically why this webinar was triggered was already a case law from 17 September 2020. And you will see on my slides, it was a full chamber of the Cour de Cassation, Supreme Court. So the French-speaking section jointly with the Dutch-speaking section, on that apparently the court itself considered this a major question, legal question in Belgium. And what happened? The facts: excavation works on the building collapses after 3 days of works, and the obviously typically a court expert is appointed, and he will calculate the actual value, so the value of the building just before the collapse, and he makes a calculation of the new value. What does it take in terms of money, personal compensation, to rebuild a house, to basically construct a new house? Contractual claim, contractual liability invoked, and they claim obviously new value. The owner and the Court of Appeal, they said, okay, we will apply our principles. You get not more than the actual damage, and we will indeed determine the indemnity based on the value of the building as it was before the collapse. And apparently, that was also one of the causes and one of the elements. It was a building in a very bad state. They were doing works that should not have affected the stability or cause indeed to collapse, but due to the wear and tear, it collapses. And they say, okay, it was already, if I make also a dump, and now you're claiming money for a brand new house. And then, surprisingly, basically, and that's a pivot change in case law of the Belgian Supreme Court. The Belgian Supreme Court said, no, okay, in principle, on the Belgian law, it's a new value that has to be paid, and there is no discount. There is no reason to do a discount for obsolescence, because that would be indeed a violation of the integrality principle. So this is a shift in case law, where indeed the Supreme Court reinforces, rather than reinforces the fact that there should be a discount for obsolescence, reinforces the fact of the full recovery, the integrity principle. The assets should be replaced and fully indemnified. Importantly, in principle, said the Cour de Cassation, so they do not exclude that there are certain circumstances where indeed there could be a discount in our view. Because the facts of this case were quite specific, i.e. there was no other option than indeed to do a rebuild, and the amount needed to build for the house to be repaired, that the damage is repaired, was indeed building a new house. So there was no other option for the injured or the damaged person than to rebuild the house from scratch. And there, indeed, the court, perhaps influenced, I believe, by the facts, although the Cour de Cassation will not rule on facts, said, okay, the integrality principle prevails, or is a principle that cannot be harmed or deviated from in principle. So that in principle, there is a lot of legal scholars that says, okay, if you would apply this judgment and that the lower courts and also the courts of appeal would follow this, then there is a problem with the principle of the unlawful enrichment, and basically the wrongdoer will have to go further than just repairing, although completely, the damage he has caused. We have then the French-speaking court, 2nd of March 2022, that basically confirms this and also concludes to a prohibition to apply a discount for obsolescence, burglary, broken window and door, tort liability claim based on new value. In front of the court, it was clear from the police report that it was a dilapidated building, so that it was really, let's say, new value would be in favor and put the injured party in a better position than before. And that's actually what the Court of Appeal ruled. Court of Appeal said, okay, we will do actual value, meaning new value minus, in this case it was 50%, minus indeed the wear and tear, so we grant 50% of the price of a replacing window and door. Then again, the French-speaking court, French-speaking section of the Supreme Court said no, and reiterates basically case law of 2020, my previous example, and said no prohibition to apply discount for obsolescence, because indeed we have the principle of the integrality, and the damages, the injured person should be able to be in the same position as before. The same position meaning having a door and a window, and the fact that a door and window is indeed an improvement as to its situation as before, with 50% of, let's say, the indemnity, he will not be able to have a new door and a new window, or a replacement door and a replacement window installed. So there, a confirmation of the, let's say, the change in case law, still with the necessary legal scholars that are playing with those principles, but yes, then the enrichment and the principle of nothing less, nothing more is harmed. And then we have on the 21st of March 2022, in the same month, we have the Dutch-speaking section of the Supreme Court that indeed basically go back to the application of the discount, and it uses basically the wording of the 2020 case law that says in principle, because now basically the Supreme Court says, okay, there is indeed a principle of integrality, but indeed we have also the principle of unjustified enrichment, nothing more, nothing less, in this case nothing more, which we will apply. And indeed, it was Court of Appeal, you read it on the slide, a concrete floor was complete in 2006, inherent defects known in 2015, need for a new floor was installed, and there the argument was, okay, new value, but let's say the liable party argued is okay, but such a floor has a lifetime of 20 years. You already benefited 9 years from the floor, so you get now a new floor. So basically, my indemnity should be lowered to 9/20 of the new value, because otherwise you will have had at the end of the day, 29 years of the concrete floor due to the indemnity paid, and that's an unjustified enrichment. And therefore, the Court of Appeal, based on those facts and those legal reasoning of the Court of Appeal, confirmed that indeed you have the principle of actual value, which is indeed the integrality principle, but that cannot lead to an unjustified enrichment. So it is indeed correct that the Court of Appeal did a discount and applied a depreciation, as you wish, in light of the use made during 9 years before the incident. And that reasoning is fully justified. So for me, that's an application basically of the 2020 Supreme case law, where there is indeed, we have the principle of integrality, but you cannot have an enrichment. So the discount for obsolescence is can be done in case of an unjustified enrichment of the victim. And that's basically, and I said I would keep it short, so I still have 8 minutes, which I will not use even. That's the status quo today of Cour de Cassation case law of the Supreme Court in this matter. Obviously, this is quite important evolution in, let's say, uncertainty in all claims for damages for damage to assets, movable or immovable property. So I believe that if with some goodwill, I think we can indeed combine the two or the principles of integrality and unjustified enrichment. Another element that we see that is invoked by not only legal scholars but also in front of court is in litigation the abuse of right to ask for full compensation. So we have, I believe, at least 2 grounds to let's say mitigate the, let's say, the revirement de jurisprudence or the apparent revirement on obsolescence is unjustified enrichment, which is now, I believe, clearly confirmed by the Belgian Court de Cassation, albeit only the Flemish-speaking section. But I believe also that it would be, it's also always a factual assessment, I believe, is the abuse of right to ask for a full compensation, i.e. new value, and setting the unjustified enrichment aside. I believe it could be also qualified as an abuse of right to ask so for the court. So how can we help it to avoid such discussions? Because it can be quite important, even just with the burglary, it's 50% of the price, but imagine it's a factory, it's a production plant, etc. So it could be quite an important difference whether to apply obsolescence or not, how we can avoid the uncertainty, obviously by contract. Many lawyers correctly states that beter voorkomen dan genezen in het Nederlands, better be safe than sorry, make a clear contract. And we cannot also do on the consequences of a breach of contract, of indeed the indemnity obligation of the parties in case there is indeed damage to goods. So it's important, I believe, that where you can to include that in your contractual relationship. I have pointed out mandatory law because indeed you have to see now more and more than before, I would say, to the unbalanced contracts prohibition in the, let's say, not only in the B2C but also in the B2B context, whether it does not create some inequality depending on the facts. But we see it indeed. Insurance law, the Insurance Act allows a party to agree indeed what the value or how the value of the assets to be compensated under an insurance policy how they would be assessed and what the indemnity would be. Therefore, in your contractual relationships, I believe it's important when drafting contracts to have an eye on that and to be very clear about that, to justify it in your contract, what indeed the assessment would be. In litigation, I'm pretty confident that certainly based obviously on the Cour de Cassation of 21st of March 2022, that the courts will combine the principle of integrality, but will not set aside the principles of unjustified enrichment and the principle, in my opinion, of an abuse of right, that indeed the victim would, let's say, have profits from the incident. And I'm convinced that the courts will do a factual appreciation if there is indeed a consumer which does not have the financial means to, for example, in that example, rebuild his house, so that in reality he's unable from a reasonable perspective to indeed restore himself in the same situation as before, that the court will be in his reasoning would be more flexible for not applying full obsolescence to the case. But in many other, in B2B context, I believe it will be still applied based on indeed those principles. But to be seen, to be argued, but I believe certainly in the Dutch-speaking section or the Dutch-speaking jurisdiction, obsolescence will be applied to property claims. I see I have still 2 more minutes, but I take the opportunity to let you go to have lunch. I hope you had some insights with this short webinar. So indeed, the idea was to give you an update of a very specific topic which concerns our practice and probably also your business and your practice. So I will leave it at that. Please feel free indeed to send me your questions on this very debatable topic, and I hope to see you, meet you, speak to you soon, and sometimes hopefully in person. Thank you so much, and good afternoon. Bye bye.